Today we shall be looking at a very relevant topic in Nigeria and other Commonwealth countries. The question goes like this: can a widow sell her late husband's estate without letters of administration? Can a widow sell her late husband's estate without letters of administration? Now, let's dive into it. What happens when someone dies intestate? This is a great question. When a person dies without a will, which we call dying intestate, their estate doesn't automatically belong to anyone. Only a representative can legally manage, sell, or transfer the estate. If there is a will, that person is called an executor. If there is no will, the court appoints an administrator or an administratrix in case of a woman. So simply being a widow does not automatically give her this authority. Can a widow sell her husband's property just because she's his widow? The answer is no. Being a widow alone doesn't give legal authority. In Nigeria, the law says that unless the widow is formally appointed as an administrator and has letter of administration, she cannot, one, sell the property, such as a house; two, transfer land; three, mortgage property; or four, lease the estate. Trying to do so without letters of administration is illegal. It could even make the transaction void or voidable ab initio. Are there Nigerian court examples? Yes. Here are a few important cases. In Lorry versus Lorry 1983, here the Supreme Court said any sale before grant of administration has no legal foundation. 2. Olowu versus Olowu 1985, only the personal representative holds legal title. Family members cannot dispose of the estate. 3. Adedonyi versus Shonuga 1999, a widow's sale without letters of administration was declared null and void. Adeleke and Iyanda 2001, the Court of Appeal confirmed that administrators cannot act before formal grant. So Nigerian law is very clear: no letters of administration, no authority to alienate the estate. What about the UK? Good question and good point. The UK has similar rules under Administration of Estates Act 1925, Trustee Act 1925, non-contentious probate rules. Cases such as Marshall versus Kerr 1995 and Crowhurst Park 1974 confirm that only a personal representation with a grant of representation can legally transfer estate properly. A widow cannot act alone until she obtains the grant. So the rule is almost identical in both Nigeria and the UK. Why is this rule so strict? Excellent question. The law protects the estate and beneficiaries by 1. Preventing fraud; 2. Ensuring proper valuation of the estate; 3. Avoiding unlawful alienation; and 4. Allowing the courts to supervise the administration. Basically, the estate belongs to the beneficiaries, not automatically to the widow. What if a widow acts without letters of administration? Now, if a widow sells, transfers, or mortgages the estate without proper legal authority, the transaction is invalid. In Nigeria, it may be void ab initio or voidable depending on the court and customs. However, in the UK, it is completely void and the court will not recognize it. So always get the letters of administration, that is for Nigeria, or a grant of representation in case of UK before handling the estate of the deceased. Now, I want to summarize. A widow qua widow has no automatic authority to deal with her late husband's estate. She must obtain letters of administration or a grant of representation in the UK. Any transaction without this legal authority is invalid. If you find this video helpful, give this video a like, comment, so that we can share your thoughts in the next video.